Hello, everyone. Let me give you a little overview of where we are, what we're going to be trying to do. We took a lunch break, so we let everybody out of recess. It's kind of hard to get them back in the room. And as soon as I get enough people to have a quorum in here, and turn off the phones, Ms. Thomas. As soon as we get enough people back in the room, we'll proceed. We got 1, 2, 3, 4. Yeah, we got a quorum. We're going to continue with the hearing on Senate Bill 420, which is Senator Utterman's bill. We've had a presentation of the bill. We have a number of people who would like to speak. Time is a little precious for us. I would ask you not to be repetitive if you can, and to try and keep your comments. If you have something specific you want to bring to the committee's attention, please do so as briefly as you can. Hopefully you can do so without going into stories of how things transpired or what may have happened to you personally, if that's all right. We'll go down the list we had. I think I'm going to call by names the way they're listed here. We have Angie Berta. Someone wanting to speak? Ms. Berta? Thank you, ma'am. Would you come up to the podium? And we'll line you up if we can. I know Ms. Henry, Faye Henry. If you will come on up and also be prepared. Is it Cheryl Schramm? I believe all of you are individuals who have been involved with the question of taking care of either grandchildren or great-grandchildren as part of your activities, correct?
Actually, I'm the program director for the Kinship Care Resource Center, so I work with grand families.
Fine. Why don't you tell us some more about your support of the bill?
Okay. Actually, as I stated, I'm the program coordinator for the Kinship Care Resource Center. It's located in Clayton County. It is the official replication site for the state of Georgia for resource centers for grandparents raising grandchildren and other relative caregivers. We are not a private entity. We're funded through the Governor's Kinship Funds, the Atlanta Regional Commission, and also through state DHR. Of course, it is all grant funding, and we do serve grandparents, great-grandparents, and other relatives who are raising their grandchildren. Senate Bill 4, and we brought a number of grandparents from our center with us. I serve over 100 families currently, and several of the grandparents, as well as myself, are also on Commissioner Walker's committee for some of the changes in DHR that are being worked through. The part of the bill that I'm most interested in, of course, is Part 2 would be the subsidy for the grandparents who are raising their grandchildren currently. I'm sorry. Okay. The grandparents that are in our program are grandparents who stepped up and took their children before they went into foster care. As did many. A lot of times they don't realize that they're not involved in the DHR process when they get a phone call that says, come and get these kids, or they're going to foster care. When they come and take them, they've basically written themselves out of receiving much needed additional help. And we're thankful for the kinship dollars that are being released for grandparents to become foster parents and relative care subsidies, but those monies are only available to grandparents who don't have their grandchildren yet.
Unrelated.
Right. It's totally unrelated. Faye Henry here is one of my grandparents. She's actually raising 2 great-granddaughters. I have one in the audience that's raising 4 great-grandsons. These folks stepped up, whether they had the means or not, to prevent the state from having custody of their children. We've all heard horror stories about this. But Senate Bill 420 currently, I have a grandparent who has 5 grandchildren that she's raising. Currently she gets $378 a month total for the 5 grandchildren. If she were to abandon those children to foster care, a foster parent would get close to $2,500 a month to provide for those children's needs. My stand is these children are just as valuable when raised by family members when the parents cannot, as opposed to the state doing it. In the Part 2, there are provisions to eliminate fraud. In order to be included in the pilot program, they must have legal custody or guardianship, which means a judge has to have found it's in the best interest of the child not to remain in the home. They must be at or below the poverty level indicated in the bill, as well as participating in one of these established governor-funded kinship programs around the state, so that we're serving the entire family. We know the family. We know closely because we go to their homes, we know these families. So even as an extra layer of fraud protection, so to speak, not only must a judge have found it's in the child's best interest, but they also have to be participating in a program that serves the whole family. So I would urge you to vote yes on this very, very important legislation. Time is of the essence. We have 6 session days left.
Thank you, Ms. Bird. I'm going to state I've known Faye Henry for a number of years and know her to be a very caring, loving, devoted person to family members. And I'm glad to see you here, Ms. Henry.
These grandparents, if I may say, since January have been here every week, 1, 2, 3 or more days a week, knocking on you guys' doors, ringing your telephones. This is important to them. If I may also speak, as part of the committee that DHR has set up, the changes are wonderful. The changes as far as foster and relative care will only affect grandparents who get their children in the future. And as for the changes that are being made, right now they're only targeting grandparents that are 60 or over and at poverty level. But I have grandparents that are 55, and the cost to raise a child at 55 is still the same. So this would, in addition to the DHR, we feel that this bill in cooperation will serve many, many more grandparents in the state.
Good point.
Thank you for your time.
Good to have you here.
Any questions?
Anyone have any questions of Ms. Berta? Yes, ma'am.
There was a pilot program done under DHR's, and I think there are about 1,100 eligible. Do you know what I'm talking about?
The first I heard about it was when you mentioned it in the other meeting. So either the word either didn't get out or not really sure.
Secondly, does Georgia have to get a waiver from the federal government to do what the district does?
Not that I'm aware of. Thank you.
Thank you, ma'am. Ms. Henry.
Thank you. My name is Faye Henry, and I'm a great-grandparent raising 2 granddaughters, great-granddaughters, and they're very precious to me, and so I'm more than happy to be here to speak on their behalf. This is not about grandparents. It's about the children. These children are in need, and when we get the children, there's been a lot of discussion this morning about the parents' right. These parents don't really care. If they did, they'd have their children. They've left it up to the grandparents to raise them because most of them are on drugs or incarcerated or something, where the children are left alone. When mine came to me, they didn't even have a coat on their back, and it was in February 3 years ago, and all they had was on their back. And we as grandparents are on fixed incomes, and with gas bills to heat the homes running $300 and $400 a month, it's really hard to make ends meet. So we urge you, please, to vote on this today because we are running out of time, and we would appreciate anything that you can do to help them because it is about the children and not about us.
Thank you. Ms. Hendry. And Ms. Schramm, you've got also Larry Schramm. Is that your husband?
It happens to be, yes.
Okay. Can y'all present together then rather than separately?
Well, actually, I'm representing the Georgia Council on Aging, and I just wanted to let you know that the Georgia Council on Aging is in strong support of this bill, both the power of attorney and the subsidy, particularly the subsidy, because we've met with hundreds and hundreds of grandparents, and many of them are in just dire straits. So I just wanted to let you know that the council strongly supports it.
Yes, sir.
And now I'll yield the floor to my husband.
Schramm, you're Association of Retired Persons.
Thank you, Mr. Chairman, members of the committee. I'm always following her. I just wanted to let you know that I represent AARP, and we're a nonpartisan organization. We have over 940,000 members. AARP Georgia strongly supports Senate Bill 420, excuse me, grandparents raising grandchildren, especially Section 2, the subsidy portion. I didn't know if you might have any questions that you wanted to ask me, but just wanted to make it clear that AARP is 100% behind this bill.
Thank you for speaking to us.
Thank you.
And we have one last, Kim Raymond. Ms. Raymond, do you want to speak? Here you are.
Just to say I'm in support.
Let's do it at the Boston, if you would.
I'm with the Senior Citizens Advocacy Project, which is sponsored by the Georgia Gerontology Society and the 12 area agencies on aging. We are very much in support of this bill. We worked with the Coalition of Advocates for Georgia's Elderly to get the bill to Senator Unterman, who has carried it thus far and done a great job. And so I do wish that you all would pass the bill out today. Thank you for your consideration.
Good. No, the speakers is now in the breast of the committee, and I'm going to have committee discussion. You need to raise your hand so we can recognize you because of the microphones. So if you have any discussion or comments among the committee. Ms. Oliver.
I posed a question earlier to the committee about to what extent the non-custodial father should or should not have the same authority to revoke the power of attorney as his other custodial parent. And I think that how I'm answering that policy question to myself is if the non-custodial parent is a legal parent, I think that, and I'll use the term he, should have the same right to revoke, because otherwise you're requiring the non-custodial parent, who is a legal parent and has to go through a litigation that he's going to win. It seems to me it's creating a litigation step.
I think it's true the bill does not speak to those circumstances in any way. It leaves it, I guess, either open or in doubt as to what is the effect of a non-custodial parent. Senator Odom, we talked about this a little bit at the time we were getting ready to go on lunch break, and I think we're going to try and do some language here that may at least give direction on that point. Not resolution so much, but give direction to it.
And if that is the wish of the other committee members, if you have to agree with me, instead of requiring the father to go to court to revoke the power of attorney, I think the place that it might appropriately go is on page 3, line 18, following address.
All right.
I think it should say something like, and I just suggest this is not an amendment for discussion. The legal non-custodial parent shall have the same authority to revoke the power of attorney as the custodial parent. And I'm putting legal in there because I'm trying to think whether you need that because of the father.
Actual parent? Actual non-custodial parent?
The legitimate child is not going to get notice for this bill. Because he's not a legal father. That's okay with me, but I'm saying that are the circumstances where a father is a non-legal
Natural.
father has a visitation order. I don't know if they
Yes, sir. Representative, recognize Representative Hatfield.
Yes, Mr. Chairman. Another concern that I have about the bill is that it leaves the custodial parent solely in charge of designating which set of grandparents would be the most suitable for a power of attorney. And there may be many situations where non-custodial parents, mother or father, may be much more suitable custodian than the custodial parents. And so I certainly think that that's a consideration that needs to be looked at. But in terms of what our previous discussion with Representative Oliver was, I had concerns about anything that would put a undue burden on a non-custodial parent in this situation where their rights would be subjugated to the rights of the grandparent. And I really, again, I'm going to reiterate that I really have reservations about the constitutionality of this bill.
Yes, sir. Okay, Representative Lindsey.
This doesn't have a pure question. I really don't. I'm certainly for policy, and I'm looking for those of you who do domestic law to help me out here. But I personally think it would be a good idea for the custodial parent has been given that authority by the court. The custodial parent is in a situation where they need to do a power of attorney to the grandparent. Presumably they'll do it to. Usually they'll do it to their own parents. I don't have a problem with if the non-custodial parent wants to revoke that, have to go to court. And I want to understand why that's such a bad thing. I think that provides a little bit more certainty to the child and streamlines the process. and require the non-custodial parent to actually make an affirmative step to enforce their rights, as opposed to simply be a hindrance toward the child's welfare. I just sort of want to hear that. That's my first blush. I just want to hear from those of you who do domestic law on that.
My question.
What's your number? 8. Okay.
My question, Representative Lindsay, if under the scenario, because I think we have to put something into the silent area for the non-custodial parent, but what happens when the non-custodial parent revokes the power of attorney? Where does the child end up? So that was, in addition to his question, you've already answered that.
Ms. Oliver, excuse me.
As a practical matter, I think I'm aware, I've had this committee is too, that most of the children that are with their grandparents have been abandoned by both parents. But I'm looking at that much more narrow group where there's been a litigation between the parents, or there's been a settlement contract, divorce is recognized, and the non-custodial father is an active ongoing parent. The mother should not be able, should be allowed to eliminate his right of custody, because he's presumptively a custodial parent, to avoid any active litigation that's threatened. I am very aware of these litigations, and I just don't think imposing the cost on the non-custodial father hadn't done anything wrong. They had done one thing wrong. Other than not custodial parent for reasons we may not still be able to, but if an emergency arises for the custodial parent, he shouldn't have to go to court to assert his presumptive right.
But let's get on top. Still seeking education here. In terms of the child and giving the child the most stability, which way would give the child the most stability?
Yeah, I think it's a case-by-case situation. I'm not going to presume. This Harpo we're dealing with the father. If the non-custodial father is a good father, he's going to win. He shouldn't have to go to court. He shouldn't have to pay. I don't think the father's argument.
Mr. Hatfield.
Mr. Chairman, the situation that concerns me is not so much where both parents have essentially abandoned the children for one parent, but where you have a custodial parent that's just purely sorry, but he or she has a set of parents, grandparents that want the child. And in that situation, I have seen numerous cases where basically a non-custodial parent is put in a situation of having their rights abused. And I don't think this ought to be used as some sort of substitute to allow a grandparent to get custody of a child and take rights away from a non-custodial parent. I think that if there's some reason that a non-custodial parent is not a fit and proper parent, then the grandparent's got a remedy to go to court to seek custody of the child. But this is subordinating the rights of non-custodial parents to those of grandparents, and I strictly disagree with that proposition.
Any other discussion among the committee members? At this point, we wish to entertain a motion. The move do pass. Discussion or amendments as to the motion? May I have an amendment? State your amendment, please.
Page 4. I believe the best way to handle this is to add a new paragraph Q. That shall, and I invite, which I know I'll get, right? An agent, grandparent, or great-grandparent shall be obligated to comply with any existing order of the court relative to visitation or any other directives relative to medical needs of the child.
Have you got that written out?
Yes, sir.
Could you submit it to me, please?
Yes, sir. I'll be doing that.
We'll try. You got to read it for the top. An agent, grandparent, or great-grandparent shall be obligated to comply with any existing order of custody. That's where you lose me.
Here's a possibility, any existing order relative to the child, including but not limited to custody, including but not limited to visitation.
Custody and visitation.
The custody doesn't make it.
No, they doesn't. No. Mr. Brumby?
Sir?
Are you writing it down?
Yes, sir.
When you have something you think would be acceptable from a legislative council standpoint, why don't you word it for us and see if we can get approval on that wording.
The other option is in paragraph K, we could insert that language also if there's any preference by the end of paragraph K on line 11.
I think you're dealing with something different there as far as the objection part. Let's do that. Wait till you get through this. Okay, ready, Mr. Grundy?
Mr. Chairman, as I have it, you would be adding on page 4, after line 32, a new subsection Q to read, an agent, grandparent, or great-grandparent shall be obligated to comply with any existing, I think Ms. Albert's phrasing the order, I wonder if you might want to say any existing court order relative to the child, including but not limited to any visitation order.
All right. Mr. Hatfield, you had a question?
I have a question, Mr. Chairman, which is direct to legislative council. Mr. Brumby, you remember you said the grandparent visitation statute was struck in a few years ago.
To some extent.
Do you have any opinion about the constitutionality of this bill in light of that decision in the Supreme Court?
Well, the court standard is articulated in that case, to the best of my recollection, was that the parents have a primary right to control their child, to which you cannot grant a third-party superior rights except to avoid harm to the child.
So with this bill, where the author has admitted that it's paramount to giving the grandparents custody of the child in opposition to the rights of the non-custodial parent,
Well, let me.
would it be constitutional?
I don't want you to try to paraphrase what the presenter said. I don't recall that being the position she took, Mr. O'Deal. You're saying your opinion may be that point.
Well, may I answer that?
Well, I think as Representative Oliver pointed out earlier, the bill is, and I must apologize for having made only a cursory study of the bill, and I'm filling in for what's happening, but I think the bill is essentially silent with respect to the rights of the non-custodial parent. And I would think, ultimately, unless the non-custodial parent is somehow unfit, their superior rights to the child would not ultimately be defeated. And I have to work to regain those superior rights in day-to-day practice. I don't know. I think it's silent. If you have a court following the doctrine that I remember from that case, would they say that this is somehow allowed that grandparent to acquire superior rights to the child above and those of the non-custodial parent? The ultimate answer would be no. I think the question would be what path do you follow to get there?
Any other questions? We're on the motion to amend, first of all. Motion to amend at this point. Any discussions on the motion to amend as presented by Ms. Albert? Ready to vote on the motion to amend All in favor signify by saying aye. Aye. Opposed, like sign.
No.
I believe the ayes have it. Ms. Oliver?
I have another amendment.
State your amendment.
On page 3, line 18, the following sentence inserted. The non-custodial parent, who is the legal parent, may execute a revocation, shall have the same authority to execute a revocation of the power of attorney as the custodial parent.
Get that from Mr. Bundy.
Not entirely, Mr. Chairman.
Non-custodial parent, who is the legal parent, may execute, but shall have the same authority to
Take it slowly.
execute.
Take it slowly for me. Probably like me.
And I guess the committee would consider whether this part about being a legal parent or not.
Let's go ahead and say that for a second.
The non-custodial parent, who is the legal parent, shall have the same authority to execute a revocation of the power of attorney as granted to the custodial parent.
What your intent, as I understand there, is to give the same level of rights which already exists to that parent, but to clarify it as far as this statute that we are not trying to remove or dilute that authority, even though that parent is a non-custodial parent.
That's exactly right, Mr. Chairman. And the reason that this is not an unconstitutional provision because the power of attorney is not a grant of custody because it's so limited. I mean, it's really, in that way, it's actually weird circumstances. The United States Supreme Court is, I think,
Any discussions on the amendment? Mr. Lindsey.
In light of our discussion regarding the concern of constitutionality and non-infringing upon the rights of a biological parent, I think to protect this bill's overall constitutionality, I think pull back from my earlier position.
Okay.
I think the whole bill constitutional.
Any further discussion on the amendment? Would you restate the amendment for us, Mr. Brumby, so we have that all in place, Mr. Brumby? All right.
Chairman, I have page 3, line 18, following this verbiage. The non-custodial parent who is a legal parent shall have the same authority to execute a revocation of the power of attorney as granted to the custodial parent.
Everybody understands the amendment. Any further discussion on the amendment as stated? All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. The ayes have it. Any other amendments or discussion on the motion? The motion before the committee is due passed as to Senate Bill 420. All in favor of the motion due pass signify by saying aye. Aye. Opposed, like sign.
No.
Ayes have it. Thank you so much. We're going to hope to get this out for the rules quickly. I'm going to take it, Senator Harper, about a 5-minute recess to get everything put together for the discussion on child support. I know you're limited time-wise. We'll get you in right away. Give me a couple of minutes.
Little piece, somebody.
It's already been negotiated with the see what's fair based on your schedule. I just say that.
I don't know. I guess there's still anybody sitting there. We'll leave this for like a more. Well, I don't know. I'm not feeling too I know. I'm peaceful. I don't even have a page.
The other members of the committee back in place. Would please, we have Senator Hart. I appreciate your coming before us. I know your time is limited. You've got a 2:30 committee of your own that you want to get started on, so I'm going to allow you to present to us 382. I want you to give us, if you could, a background as to what came into the Senate, 382, the way it was structured, why it was structured, and what occurred as far as changes in 382 as it went through the process.
Well, Mr. Chairman, first of all, y'all were briefed extensively. I participated with the Honorable Louisa Abbott from Savannah, who did a tremendous job of explaining 382. I bear the title of author of 382, but that is really not correct. 382 is the product of the Child Support Commission. The commission was commissioned by House Bill 221, which we passed last year and which goes into effect on July the 1st. 382 is a rewrite of that, not a derogation of what House Bill 221. In fact, it really doesn't change the policies of 221. What it does is it makes it a whole lot clearer. I cannot tell you how indebted the Commission is to Judge Abbott in particular, and to a lesser extent the other judicial members that participated in the Commission, because I think 382, when you read 382, you will find it's one of the best crafted pieces of legislation in terms of a bill that works, that takes a complicated situation and makes it into common sense, and it essentially makes the determination of child support much easier to understand, much easier to do the calculations. And the second thing 382 does is 382 presents the tables that House Bill 221 required the Commission to prepare. I'll talk about the tables and then I'll back up and talk about the bill. I'm going to give you a little background about the tables. We and the Commission, I'm Vice Chair of the Child Support Commission, sat there and we tried to determine, first of all, how much it costs to rear a child in Georgia. Instead of just taking some arbitrary panel's decision, a table, because of my role as chairman of higher education in the Senate, I was able to prevail upon the Board of Regents. And the Board of Regents then commissioned and directed 10 different economists from our university systems across the state. And they each did an analysis in their own particular region so that they came up with a determination of what it costs to rear a child in Georgia. That information was compiled by Dr. Roger Tutterow, who is now at Mercer University. He was at the time he was at Kennesaw. I think he was the head of the economics department at Kennesaw. And crunching those numbers, he compiled the recommendation of the economist. And the recommendation of the economist was to use a hybrid. And when I say a hybrid, you will find that there are a number of studies that are out that have been done. One is Rothbard. The other is Engel. Engel is traditionally a higher dollar amount. Rothbard is a lower dollar amount. Our sister state, Alabama, and the surrounding states use Rothbard. Based upon the economic circumstances of Georgia and the determination of cost of rearing a child in Georgia, the recommendation to us, which was adopted by the Commission unanimously, was that we use a hybrid between Rothbard and Engel, which is an average. It's an average between these two tables. Then what we did is, after we had made that determination, we then hired what is considered probably the best firm in the country, PSI, out of Denver, Colorado, and they then took the average figure that we had determined, and in saying we were using the average between Rothbard and Engel, they then constructed the tables. Those tables are part of 382, and that's the codification that you find at the back of 382. 382 has another very unique feature, and that is if you go through the bill, you will find words capitalized and phrases capitalized. And the reason for that is, and this is unique, if you see a word in 382 that is capitalized, that means that that word is defined in the definition sections of the statute. So for clarity, you find that is the situation. There's been a great deal of confusion about how do you compute child support. It's fairly simple. It's fairly straightforward. This is an income shares model based off of House Bill 221. And what you do is you add the gross income of both parents. The total of the gross income of both parents. Then you go to the table and you look at the number of children, and that tells you what is the presumed award of child support. That presumed award of child support then would be allocated between the parents proportional to their income. And by that, suppose the mother makes $4,000 and the father makes $6,000. They have $10,000 a month. Then what that amount of support would be the father's portion is 60%, the mother's portion is 40%. Those proportions are critically important because as we go down the remaining parts of the calculations, the second step is health care, health insurance, and daycare. Those two, whatever those amounts are then allocated on that 60-40 ratio that I have said. And then finally there's the time adjustment. And the time adjustment, I believe Representative Lindsay has a proposal that he's going to do in terms of the 90 days. The Senate moved from 90 days, which the Commission had recommended, to 120 days. I hope we will go with the 90 days because the 90 days has the cliff effect. The cliff meaning it's a starting point. It drives people to litigation. People want to go to the 90-day time so that they can get some recognition of visitation. If you look across the country, you'll find different states have different amounts. Arizona, which was the model of the time-sharing formula, starts with 4 days. So when you see 90 days, we're back to what? What the time-sharing number represents is a recognition that the non-custodial parent has the child a significant amount of time and bears the expense for food, clothing, and shelter of the child during the time that the child is with that parent. Now, 90 days is roughly a quarter of the year, and under Representative Lindsay's tables, which I would say I have examined and find them to be acceptable, I would have no problem with Representative Lindsay's proposed adjustment on the tables. I think that would be a step in the right direction of getting, but that gets us to the 90-day cliff. hopefully will mean we will not have a great amount of litigation, but it gradually spreads it up to where there's equal time between the parents. At equal time between the parents, there would not be child support, except in the scenario where the only time you will have no child support is where the parents have identical income. In other words, if they have equal time and identical income. If you have a scenario where you have the father makes $200,000 a year and the mother makes $20,000 a year, even in this scenario, if there's equal time, the father will be paying child support to the mother because of the scenario of the time frame that we're talking about. It makes sense. I applaud and I thank my commission. It'd take me about 15 minutes to thank everybody that has been involved in this process, but I want to say this. This process has included the bar. We invited the family law section of the state bar. Now, they didn't endorse it or anything else, but they participated. They have not taken a position on it, but we invited their participation. We invited the members of the American Academy of Matrimonial Lawyers. They participated in it. All of these people were heard. The matrimonial bar, as I say, the Judiciary. We had, I believe, 3 members of the Superior Court, a Court of Appeals, and a juvenile court judge that sat on the commission. So we had a cross-representation of the legal community. We had public hearings. We had public hearings in Atlanta, Columbus, Albany, Georgia, and Savannah, Georgia. We went out and vented this bill through the entire state, trying to get the word out, and we've done everything in our power to try to educate the process. Upon passing this bill, we will quickly, immediately have seminars. We have an all-day program with public television, which is going to broadcast to educate the public. We have a number of continuing education programs that are set up through ICLE, and that will educate the bar. The judicial conference is set up to go forward in terms of educating our judiciary. So we are ready to go with the bill. But if you look at where we are, House Bill 382 simply clarifies and makes 221 much more functional, much more readable. Doesn't change the policy, but it does have the desired effect of making this a whole lot better law. I'll be happy to answer questions.
Thank you, Senator. We'll have some questions.
And I apologize, I got about 5 minutes or I'll kill all the House's education bills.
We'll try and get you out.
Thanks, sir.
I think there has been a lot of participation, Senator, but I believe, tell me if I'm wrong, that the folks that were participating were told this bill is going to pass and the policy is not going to be changed.
Well, Ms. Oliver, if it doesn't pass, 221 is the law. And 221 is, for all practical purposes, is 382 without the clarification of it. And that's the law. That is enacted and signed and ready to go.
So I assume that the fair answer or comment might be because the participants didn't necessarily endorse.
Well, did they enjoy it or?
Endorse.
I can't say that. I think they did because we took a number of votes and there was unanimous approval of the various aspects of what we've done. Now, the idea of income shares, I'm certain people have had reservations about income shares, but that was already where we are.
My primary concern is that when I apply the tables to upper middle income people, and I don't use the term high income, but we can debate that, it universally lowers child support.
Not necessarily.
And every case I've looked at, that's been true. And I asked you whether that's your legislative intent to lower child support for upper middle income parents.
Absolutely, that was not my intent. My intent was to create a system that's fair and to recognize the fact that individuals that have higher income have and suffer from the graduated income tax. And because they suffer from the graduated income tax, the present system in Georgia is woefully out of line with the real world, because no one can pay a flat percentage is just totally out of skew with the fact that you have an income tax level that's going up and taking a larger portion of the income, and you have a child support award that's flat.
Okay. Now, let me resolve those. I have some other people whose time's limited, so I know your position on it. Anyone else have any questions regarding members of the committee? Mr. Lindsay?
Yes, sir.
Just to clarify for the members of the committee and also the audience as to my suggested proposal, basically what it does do is kind of reach a compromise between SB 382 as originally written and as it was passed by the Senate.
That's correct. The Senate took the time frame up to 120 days by amendment. But what your bill does is it effectively takes it back to 90 days. But your amendment would take it back to 90 days, but it would take the percentages so that there's a much smaller percentage on the front end, gradually loading up to the 180-day period.
Basically, you start at 0.3% at 91 days, and at 21 days, you're at the 10% mark that's already in the bill.
Correct.
You take it up from there on an incremental basis, so we can avoid the present tax.
That's correct.
All right. I've got a couple of questions, if I might.
Yes, sir.
Other than I thought the visitation matter that was just discussed, was there anything else the Senate changed as far as?
Yes, sir. They did. There was a contempt provision added to provide for the powers of contempt to be evoked in the event a person who has sought the advantage of the time adjustment and then did not exercise that. Now, I have been informed after the amendment was brought on the Senate floor, it was not brought in committee, that cannot be done in a 4D case. A 4D is one of our welfare cases or TANF cases. Consequently, that does not need to apply, and that needs to be specifically accepted from the 4D case. Second of all, and again, I think it would be fairer if we did it twofold, and that being that the power of contempt could be brought against a parent who did not exercise the visitation, but by the same time, the power of contempt ought to be used in a gender-neutral matter against the parent should that parent withhold the children to defeat the time-sharing arrangement. And I think it should be a gender-neutral situation where both parties can find themselves before the judge and let the judge figure out who's not visiting, who's withholding.
Well, as to your last point, is that not already the case as far as the ability of a parent being denied visitation has a right to?
Yes, sir, that's true. That can be done.
The law itself discusses that, but does the law discuss the contempt where a parent is failing to do what they said they would do? I don't know if we have that.
Traditionally, that has not been the law. And the law as it exists today in Georgia is that a parent, but there has never been a tying of a dollar amount to visitation. And this bill certainly ties visitation with the amount of child support because of the reductions that are by the time credit.
One other question, actually two more. I'll ask this one first.
Yes, sir.
The percentage amount we have in the bill reflecting a change for where a party has a right to seek a court review is right now at 15%.
Yes, sir.
Two things. Do you have an opinion about that being an appropriate threshold?
The reason we chose 15% is right now I'm told that the Department of Human Resources in the review and auditing of child support orders, which HHS under the welfare laws requires us to do every 3 years, they use a threshold of 10%. So we increased it from 10 to 15%. Now, Ms. Oliver has brought out the fact that there may be some very large amounts. I am not opposed to the idea of a phase-in if you're dealing with a very large amount of deviation from support.
Here's a concern, Senator Arthur, I have on that point that I've heard discussed. That is, a lot of times as parties sit down and work out an agreement to a divorce, dividing up the house, the furnishings, the assets, and payments of whether it be alimony, not alimony, or there be child support and adjusting of child support, they consent to these things which may have brought about a variation of that amount as far as child support.
That's correct, sir.
And I'm concerned if we're going to be opening up Pandora's box to all these where there have been consents, which brought about a variation because the parties agreed to it, yet under the 15% rule, they may still be entitled to automatically seek a court review, whereas otherwise they'd wait 2 years.
Mr. Chairman, you've hit on one of the areas that's probably a concern that we all have, but the other side of that coin is if they've done that, and with some tremendously fine domestic relations lawyers in the audience, and any of us that practice in this area do this. And what it's called is very simply you're shifting dollars into a non-tax dollar from a tax dollar. If you give them alimony, alimony is taxed. It's includable, deductible and includable. Well, unfortunately, the IRS doesn't like that. And while we have done this, and the IRS, at least in our part of the nation, has been kind of looked askance and not done much with this, we have had, I have had real reservations because of the fact that under private ordering, and that's the terminology the IRS will use, under private ordering, people do this, right. And I recognize that. So if you want to address that, I'm certainly amenable, again, to do that. But I think that was considered by our commission, and generally speaking, we were conflicted because of the fact the Internal Revenue's position is that you're not supposed to transfer alimony through the vehicle of child support. That is a no-no with the Internal Revenue Service. But do we do it? Yes, sir.
One last thing. Do you have any concerns regarding the rapidly approaching enactment date of July 1 and our ability to get the education of this bill throughout the state, the training that needs to be done?
That I don't. And the reason I say is the Commission has been at work for a year of effectuating 221. We have set in place, the Commission has set in place a number of education forums that will be available. I have participated already in 2 major seminars with the bar. The word is out there. Everybody knows it's coming. I'm told the judicial conference the subject will be on the child support bill. The only thing they were concerned about is us getting it to them quickly enough so that they can do that, and I believe they do that next month. They do that next month. This is one of the major subjects of discussion that will be done with the Family Law Institute in May. It's out there.
Have you had any discussions with the governor's office about when this is passed, of course, to be finalized by the end of the session, what his expectation is signing the bill, because he has 30 days?
Well, we're hopeful that your powerful chairman of the Rules Committee will have an appropriate influence on getting that done. And I think he has a good relationship there.
That's all the questions I have. Anybody else have a question of the presenter? Ms. Oliver?
On page 14, line 25, reference to at least 10% per year. Where is the 15%?
The 15 is the criteria for examination of. Ms. Oliver, I don't have a copy of the bill in front of me, and I'm sorry I didn't.
Can you compare it to the paragraph that I'm looking at? That's what 10% is, and I can't find it.
Page 26. Page 26.
What is this?
That's what we'll discuss that in a second. Okay, here we are. The child support obligation table set forth in subsection O of this code section creates a difference of 15% or more between a new award and a prior award.
Right.
That's on modifications.
Page 26, line 34.
The one you had, Ms. Oliver, was page 14. And dealing with what line?
Line 25.
Oh, that's okay.
This is when they're going into court and they're
right.
Imputed income, isn't it?
Yes, sir.
Under imputed income, right. somebody says, well, I won't give you my income.
That's right.
Then you have to establish something. You do it by an imputed income.
That's correct, sir.
And then they come back and say, wait a minute, I've got proof of it.
No, you don't. You had your day in court.
Any other questions, Ms. Oliver? Thank you today.
Thank you, sir, and I appreciate it. And now go take care of your bills.
All right.
Thanks.
Good to have you. What we're going to do now is I have a number of people who are wanting to speak on the bill. Please understand I'm going to have to require there be brevities due to your numbers. I want to give people a chance to speak and ask you not be redundant from what may have already been spoken by someone else prior to your speaking. If you're representing an organization, I prefer that you do so on behalf of addressing your comments on behalf of your organization and let us know that you are representing that group as opposed to individuals. We don't have any particular order of these. I'm going to call them as they came in on the list. And I'm going to start out with Ms. Holliday, and I'm going to have to request that you can keep your comments, if all possible, within 2 minutes, Ms. Holliday. The next I'll have is Steve Woodward. And Mr. Woodward, you be standing by. Please up the podium.
Hello. My name is Allison Holliday. I'm the custodial mother of 3 minor children. I'm the reality of what House Bill 221 will do to families of custodial parents. You can look at me and see what many other custodial parents, mostly mothers, are too intimidated to pursue. You can look at me and know that most other mothers have not delved into this issue to the extent that I have. I am one face of many that will discover the economic devastation that will be caused by House Bill 221. I'm not a political activist. I don't have an organized group behind me keeping me abreast of the latest legislative rulings. I'm just a mom in Roswell trying to raise her children under the already stressful umbrella of divorce. I recently attended a seminar that required experts to decipher the meaning of this bill, as information has been very difficult, if not impossible, to understand. We're the few that actually have some understanding of the bill and the proposed child support calculations. What we found out was terrifying. It is imperative that all lawmakers understand the negative economic impact this will have on mothers of children in our state. As it is, I can count on my current child support being slashed by 55%. Here are some certainties if this happens. I'll no longer be able to afford the modest house I live in with my children. Upon our divorce, my ex stayed in our marital home. I purchased a home in the same neighborhood, which allowed our children to be near their father, stay in the same neighborhood, same school, same friends. I'll be forced to sell our home, and likely to a different school district, and possibly not within close proximity to their father. I'm shocked that their father, who's been largely responsible for spearheading this new legislation, would jeopardize this arrangement for his children, but he has, and seemingly in the name of money. I'll be straddled with more mounting attorney's fees that will likely exceed $15,000. My children's activities will be cut, if not completely eliminated. The court system will be backlogged for months as a result of the new litigation. This is no concern for non-custodial parents, since modifications will be retroactive to July 1st. Regardless of when the case is actually decided upon, how are custodial parents supposed to support their children on phantom support? Is it not the goal of the state to maintain the standard of living for Georgia's children? My ex-husband earns an income well into the 6 figures, and I make roughly 25% of what he makes. My children's support will be greatly reduced, and I'm not making enough to absorb the impact. Our agreement was reached over 3 years ago. My children's standard of living was determined then. Why should they have to suffer for this?
Thank you, ma'am. So they need to bring it to a conclusion. You're opposing Bill 382.
I am opposing it.
As I understood from your comments, your agreement was reached as a matter of negotiation with your husband?
That's correct.
Thank you. I'd like to ask you to step aside and go call Mr. Steve Woodward. And next I have Bill Fussell, or Fussell? Fussell, excuse me. You be next, please. Mr. Woodward.
First, I'd like to thank the committee for your time and letting me speak to you about this bill. I'm urging you to support House Senate Bill 382 as originally submitted by Senator Hart. The bill is fair to both parties by taking into account the incomes of both parties. Current college populations are half and half, male and female. So when you have both parties making high incomes, why shouldn't you take both incomes into consideration rather than have the full financial responsibility based on one person? Also, I have one child. I pay over a third of my income, after-tax income, for one child. How many households in this country do you know that happens? And I have my child half the time. So this bill would rectify the problem with that. Thank you.
Thank you, sir. Mr. Fussell?
Fussell, Ron.
Yes, sir. Next would be Michael George, if you prepare to come forward. Mr. Fussell, if you will take the... Yes. His hand at the end. Okay, great.
I'm in support of this bill. My sole subject that I want to talk about is the amendment number 6 that was passed in the Senate, which was Senate Vote 604. What that amendment did not only changed the number of days, and by the way, I don't know if it should be 91 days, 100 days, or 121 days, or 132 days. I don't know. But I do know this. The definition of day, as it currently stands, subsequent to Amendment 6, guts the concept of an overnight stay. And this little handout just gives you some examples of the current, the way 382 sits currently this moment. The only time a day is counted would be a 12 hours, at least more than 12 hours within a calendar day. So anytime you picked up a child, say after school, took them to school the next day, you'd get no credit for that under the current definition. So Amendment 6, which changed the number from 91 to 121 days, instead of just tweaking the table, cut all of subsection G and inserted the old subsection G. It no longer works because the definitions are not in the old section G. They're in the rest of the pre-filed 382. So that is a sole subject. Just would like to have day to include overnight stays. I think without that, it's going to be grossly inequitable and very hard for people to understand. When we talk about a day, most people are thinking, well, yeah, if I picked up my son at 1 o'clock on Saturday and cared for him all day Saturday, took him to church Sunday morning, our church gets out at 11:30 and dropped him back at mom's before noon, that'd be a day. Currently, it wouldn't be. So it's real definitional. Just would like to include overnight stay, which was in the pre-filed 382. Thank you.
Any questions of Mr. Fussell? One question I have, the definition previously was 12 hours.
The definition is more than 12 hours within a calendar day. The committee, the Child Support Committee, grafted in the concept of overnight stay. So you couldn't get a double dip. If you had the more than 12 hours, you were counted. And then there's a further definition of overnight stay in what in the pre-filed, if you will, the pre-filed 382. So it's a definitional tweaking of the initial cap word DAY, day.
Thank you, sir.
Thank you.
Mr. George, next we have is, I believe, Vin Anapu. If you're present, be prepared. Thank you.
Thank you, Mr. Chairman and members of the committee. I have one comment about the language on Section 4G. I think it's paragraph 2. It says the child support obligation table is based upon expenditures for the child.
Do you have a page number?
I am reading off of the commented version of the...
Section 4?
Yeah, Section 4G, parenting time adjustment. Paragraph 2.
Parent time adjustment, page 18.
And starting on paragraph 2, it says the child support obligation table is based upon expenditures for the child in intact households, and therefore there is no consideration for cost associated with court-ordered visitation. I would like the committee to consider putting a period right there, and because I believe that part of the statement is correct, that paragraph, and it really represents the work done to put this obligation table together, and it represents every other obligation table that we know of, that it's strictly based on expenditures for the child in intact households, period. And I think we should leave it that way. I think the rest of that paragraph makes it an incorrect statement. And certainly if other language needs to be added to that to make another point, then so be it. But I'd like to see that changed. And with regard to, I think the other thing that I really like about the work that was done, I think there was a high level of credibility, a high level of integrity. I think basing it upon these obligation tables, regardless of any emotion or other feelings around what child support should and shouldn't be, that if we continue to use these tables and we say this is the cost of raising a child, it takes the emotion out of it, and it gives the children the amount of money that has been determined that they need to be raised according to the research. And I would also ask that the Amendment 6 that have been discussed be stricken and returned to the way it was originally stated under the House bill.
What Amendment 6?
With regard to the parenting time adjustment, parenting time units, that for according to what we've just heard, for similar reasons, that it be stricken. I don't know where this came from. I don't think it represents the same level of credibility, due diligence, and integrity that I see in the rest of the bill.
All right,
thank you.
Our next speaker will be Sven Anapu, and we have next Pam Gray. Ms. Gray would prepare herself to speak. Butcher your name?
Yes, you did, but it wouldn't be the first time.
Why don't you state it for us?
I will. Ladies and gentlemen of the committee, thank you very much. My name is Sven Aunapu, and despite the name, I hail from Albany, Georgia. I'm the victim of a parent with a good sense of humor. While I support the income share statute in general, I strongly object to the parenting time adjustment. As mentioned earlier, I'm a father and a husband and a Christian, and it's important that you understand that, because in the 3 minutes that I have, I want you to know who's before you right now. 2 minutes. 1.5. I currently am in the middle of protracted negotiations and may end up in trial, and primarily for a law that has not even passed yet. All right? I wanted to let this committee know that both my wife and I adamantly oppose the parenting time calculation in the statute, and this is why. Prior to the point that we are now in our divorce proceedings, we did go into voluntary mediation, and we did settle on legal and parental custodial rights. We mentioned this to our mediator, and he told us this was a good thing. Unfortunately, right now, approximately a month and a half ago, I was informed by my wife that the former agreement that we had, that unfortunately was not put into writing yet, would no longer be valid. What we're talking about is 2 Friday nights a month. And the reason it's not valid is because it's going to cost her $400 a month, approximately $400 a month in child support. The amazing thing is that I have not been fighting for custody. We're talking about something that's supposed to reduce litigation, and I'm telling you right up front, I'm going to court to fight for time with my children.
Thank you.
Okay? Thank you.
Very much. Pam Gray, and next we have Bill Kirksey. Thank you, Ms. Gray.
Thank you. I am a domestic attorney, been practicing in this area for about 8 years. I'm also a custodial parent and the higher wage earner between myself and my ex-husband. We've been divorced since my child was prior to being 1. We've been involved in 3 modification proceedings since our initial divorce, and I have already been sued under the new law that will go in effect. So I'm presently involved in litigation for a modification of visitation legislation, as well as a downward modification of child support based on a law that is not yet in effect. And what I would like to do today is to present in a very brief synopsis of what has occurred in my life since this law has got passed in approximately May. Prior to May, my ex-husband consistently and on a regular basis canceled his midweek visitation with no makeups, no requested makeups. Since approximately May of 2005, he has demanded makeups for any day, which has been a lot of days that he needed to cancel. He has demanded makeups. What this has caused is, since 2003, in our last modification, over 7 volumes of correspondence in written communications between my ex-husband and I over demanded makeups, and lawyers have already been involved. I've incurred litigation costs already. I am a domestic lawyer and actually had to hire a lawyer to represent me in these proceedings. If I suggested a dinner, trying to be a good parent and allow him time with the daughter, he would not agree to a dinner because he wasn't able to count the days. If he was unable to care for our child, he would put her in an inappropriate, in my view, daycare facility instead of letting me care for her when I had already told him I would be available to care for our daughter. So we're going to have litigation over right of first refusal provisions. In his lawsuit, he has already brought a request to be able to cancel his visitation, and with 7 days' notice, he would be able to make it up. That would be with no consideration to my child's schedule, no consideration to my schedule, no consideration to activities she had planned, but he was doing that, in my view, to avoid being held in contempt for his continual cancellations. It has become a nightmare in the counting of the days. And if you keep the day requirement, it has got to be high enough where there is not manipulation at the expense of a child.
Thank you. Any questions, Ms. Gray? Thank you for coming before us. Next we have Mr. Kirksey, and after that we have Shelley Sunifit.
Thank you, Mr. Chairman, committee members. My name is Bill Kirksey, and I'm a volunteer for an organization called Men Stopping Violence. It's a group of men dedicated to reducing violence in the home. I volunteer for this organization because domestic violence has impacted my life as a child, as a parent, as a husband, and most recently as a grandfather. And I know that a large percentage of divorces are due to domestic violence or violence in the home. As a result, the last thing I think any of us want to do is to financially motivate an abusive non-custodial parent to seek more opportunities to abuse the custodial parent. So I strongly recommend that if you're going to have a PTA, that you include it as the Senate recommended or amended at a 121-day level. And I also recommend that you keep it at the day level. Maybe you do it 12 hours, not within a calendar day, but don't have a funny PTU, whereas from 5 p.m. Friday to 5 p.m. Sunday counts as 3 PTUs. I think that this is what we need to do at that level to reduce the harassment of the children. Lastly, several men in my organization are divorced and have child support payments. They have work requirements who are not able to be here today, and they strongly support keeping the PTA at the 121-day level. Thank you.
Thank you, sir. Shelley Sunifit. Next we have is Kirsten Rambo. Kirsten Rambo. Ms. Sunifit, I believe I know you've provided me some information as far as language, and we're going to look at that as part of the bill. I just want to give you some heads up on that. We're going to talk about those amendments.
I also know And the language that I can provide you is just with respect to some technical drafting issues, not anything substantive. I want to talk to you, though, about a couple of substantive concerns that I do have. I'm here on behalf of the Georgia Coalition Against Domestic Violence, and I'm also here on behalf of my law firm, Center and Knight, in which I practice exclusively family law. I'm handing you out some materials from the National Conference of State Legislatures, which provides a summary of the way all 50 states deal with this issue of the parenting time adjustment. And if I could just highlight a couple of things. The states which have a dot to the left of them are income share states which do not have a formula for the parenting time adjustments. 10 of the 34 states which have the income shares model don't have a formula such as the one that y'all are considering. What they have is what we've always had in Georgia law, which is to provide a general deviation ground so that if there is a case with extended visitation, with shared custody, that the judge is given the discretion to say, sure, we should deviate downwards from the presumptive amount of child support in recognition of the shared expenses. And I think there's been some miscommunication. Some folks were under the impression that if we go to income shares, we've got to have this formula to calculate the parenting time adjustment, and that's just not the way all states do it. So I know we don't have time to go into the specifics of how other states do it, but we would recommend that the committee consider striking the specific formula and go back to the way, as Judge Abbott noted, I think, in the last hearing, we've always done it, which is vesting the courts with the discretion to look at this, the particulars of a particular case, and then decide how far down we should deviate rather than rigidly applying a formula. If you're not going to do that, then we urge you to keep the Senate amendments at 121 days. And I just have to respectfully disagree with some of the statements that Judge Abbott made in terms of how having a lower threshold will impact litigation. I can tell you as a divorce lawyer, people are going to fight over whatever they can fight over when they're going through these proceedings. If you make the parenting time threshold at 91 days, that's just about 11 days over what this body has already determined to be the standard visitation of 80 overnights a year. So less than one additional overnight a month is going to result in a financial impact. I believe when you've got warring parties going through a divorce, if they see that getting one extra overnight a month is going to result in that very concrete change, that creates an incentive for them to fight over it. If you keep the threshold at 121 days, what you're doing is you're setting it at a level so that where you have a truly involved non-custodial parent who has been exercising more than average, substantially more than average visitation, we reward that parent with a decrease in child support. You're then going to keep the folks who maybe really shouldn't be having that much visitation or who, as a practical matter, won't exercise that visitation from having a financial incentive to fight to get to that level. So we'd encourage you to keep it at 121 days and also to keep it at days or 12-hour periods as opposed to this parenting time unit. I think Representative Lindsay hit the nail on the head at y'all's last hearing when he asked Judge Abbott whether under the original version, a standard weekend visitation from 6 p.m. Friday to 6 p.m. Sunday would result in 2 or 3 parenting time units. And Judge Abbott acknowledged it would be 3 parenting time units for a 48-hour period. I don't think that makes sense to the average Joe or Jane on the street. And I sure don't think it makes sense from a litigation standpoint because you're going to get into huge, huge fights over this, few hours here, a few hours there. I could speak for a lot longer, but I'm cognizant of the time. I'll be happy to answer any questions.
Thank you, ma'am. Any questions? Ms. Oliver?
If we extended the implementation date to January 1st, 2007, would that help the counties deal with the 50% of the pro se and help them budget for the management of the 50% of the pro se people that are going to be trying to work this formula?
Representative Oliver, I am very concerned about the impact on pro se litigants, and I do think it's going to require a substantial shift in the way counties handle divorces where there are no lawyers. I think any additional time for the counties to get some of these kiosks available in the courthouses or potentially to apply for grant funds so they can have what Fulton County has, a family law information center with attorneys who are on site to answer questions for folks who don't have lawyers.
Another question, briefly. If we raised the modification presumption, entitled modification, only if it's 15%, if we raise that to 25%, would that have the impact of not being so egregiously detrimental to the families who have been kind of used to a certain level of support?
I think it would, Representative, and I appreciate your bringing that issue up. I have gotten calls from folks who just finished litigating their divorces. One woman said, I just paid $30,000 to finalize my divorce, and my ex-spouse has now indicated his intent to file for a modification come July 1. It certainly, as a matter of public policy, doesn't strike me as the appropriate response to have only the lawyers win, for the lawyers to get more money in fees when that money could be going to the college saving funds or to support the kids. So I'd also urge you to consider raising that threshold from 15% to, say, 25%. So you have to show a more substantial difference than just 15%. The other option that you might consider is staggering it. So you'd say those families that are going to see the largest change, let's say a 50% change, would get the first right to the courthouse for the first year or so. And then maybe in the second year, we'll let families who are going to see a 40% or a 30%, whatever amount y'all agree on. But that would be a way, as a matter of judicial administration, to control the rush to the courthouse doors, which I know is going to occur. And I know we've heard some statements that hasn't occurred in other states, but I have to tell you, I've talked to lawyers in other states, and they actually have seen the rush to the courthouse.
Thank you, ma'am. We have next Kirsten Rambo, and then we do have a Kristen Riley next. Kirsten Rambo, if you would come forward, please.
Thank you so much, Mr. Chairman, and thanks to members of the committee. My name is Kirsten Rambo, and I'm the Executive Director of the Georgia Commission on Family Violence, which includes representatives from a variety of fields, including judicial, law enforcement, DFACS, and others, all concerned with ending the problem of family violence in Georgia. The Commission is very concerned about the way in which this bill, through the parenting time adjustment, really creates a financial incentive for parents to argue over visitation. We're particularly concerned about the effects of this bill, of course, on victims of domestic violence. And I know that's not all the group of people that this is going to affect, but it is a large one and an important one, I think. So I think any of you who practice family law and have dealt with domestic violence cases know that when that power imbalance is so extreme, the abusive parent is going to love this opportunity to further manipulate the victim, and they will use it to the detriment of the children. And so we would really urge you to keep the parenting time adjustment at least 121 days for that reason. And as far as the issue of days versus parenting time units that has come up, I think, as Ms. Centerford said, this committee has considered before this issue of the Friday night to Sunday night, that counting as 3 parenting time units just isn't something that I think makes sense to us either. So we would also urge that you retain just the way it is now, where we talk about days in plain language, and we also keep the parenting time adjustment at least 121 days.
Thank you, ma'am.
Mm-hmm. Thank you.
Ms. Riley.
Good afternoon, and thank you for your time and letting us speak. My name is Kristen Riley. I'm a realtor who runs a business out of my home. I've worked tirelessly on many campaigns, supported many issues over the years. I'm a former councilwoman. I'm currently Deputy Chief of Staff for the Chair of the Fulton County Commission. I worked for the Speaker Pro Tem last year as House Bill 221 had passed the House, and at that time it put a pit in my stomach. But most of all, I'm mom to Andrew, who's 14 and attends Pace Academy. So I'm here today because I know you and you guys know me. I believe that you're up there because you care about the citizens of Georgia, and I really truly believe that you work hard to do the right thing. Guys, Senate Bill 382 is bad. It's dangerous and it's detrimental to the well-being of the children of Georgia. I'm going to share my story with you because I'm one of you, and this is real. For the past 9 years, I've been the custodial parent. My son spends 95% of his time with me. I'm responsible for everything from breakfast before school, lacrosse practice, homework, tutoring, and the 10 o'clock run to the grocery store for supplies for the next day project. And my former husband and I agreed to this 5 years ago. We had financial arrangements that were based on the laws in place at the time. My husband had his choice of any and all furniture. He kept all cash in stock. He took a fully paid off car, and he had no debt obligation. I received no long-term alimony, stocks, or cash. I received a house with a substantial mortgage to keep the same roof under my son's head that he grew up in. I took a $20,000 car note. However, in return for that, I received a substantial monthly child support payment. And during the past 9 years, John Riley and I have enjoyed a better than most relationship. I consider us good parents, and I consider us people that have considered the well-being of our child. We attend Andrew's activities together. We enjoyed Saturday's lacrosse game. And we don't fight. Gentlemen, that changed 2 weeks ago. I was served by a deputy at my front door, challenging the monthly child support obligations. My former husband was solicited by an attorney to do this. And he was told, do not discuss anything with Kristen. You don't want the tail wagging the dog. Mm-hmm.
You in a consent agreement?
Yes, sir.
Based upon how assets were being distributed, and therefore child support payments going.
They were substantially higher than they even would have been on a straight percent. Well, no, they fell in the percent range at that time, but I did not take any financial stocks, any money due to the substantial child support monthly payment I was to receive. I can't go back and renegotiate that. I mean, the stocks, the cash, the alimony opportunities are gone, and I can't redo decisions that were based on the income percentages that will no longer apply. And this affects where we live, because I'm now responsible for a percentage that didn't even exist before. And this is real legislation. This affects real people. I would suggest, if you haven't done it already, pick up the phone and call some constituents. We're all over. Single moms are in the community. Get the chart. Sit down with them and say, hey, we're looking at this, and I care about the people in my backyard. How does this affect you? You will be shocked. I cannot tell you one mother, custodial parent, that this does not affect in a major negative way. People are upset about the $2.50 addition on their gas bill. We're talking about $2,000 a month that goes for food, clothing, roof over the head. We're talking about what school the children go to. And all of this time is being spent on legislation while it's very important and it's while you're here, but somehow the magnitude of this is escaping anybody's comprehension on how big it is. This is a bipartisan issue.
Let me speak. I don't think argue with the fact we're not cognizant of what's going on with the bill. And for the last year, including last year, it was heavily debated, deciding whether this is a change of policy that was warranted this time or not.
Well, and I certainly appreciate. Well, and I hope that's correct, because when I spoke with my prior boss, I was told, and this was a week and a half ago, that the only email that they had received on this issue was from me. That's alarming. Thank you.
We have public comment concluded. Now we'll be in the rest of the committee to review and discuss the bill. Let me be sure. I'm working off what is a Senate Bill 382, and it has up there the legislative number.
Yeah, I think there are 2 more names.
We have one more? Did I miss somebody? I beg your pardon. Oh, Kessler, Randy Kessler, excuse me. Down. All right, come on up.
My comments are going to pale in comparison to the previous speaker and speakers. Thank you, Mr. Chairman, and I'll be very brief. I'm a family law attorney. We have 10 lawyers in our firm that do nothing but family law, and I would urge you to consider some measures that would reduce my income and our firm's income, because I think this litigation is going to increase lawyers' income. I think, number one, 382 is much better than 221 was, and I'm grateful also to the work of the commission and the lawyers and the bench. 2 points that I want to make that I think are going to increase our revenue, and I wish that they wouldn't. Number one, the 15% automatic right to get right back into court. Consider this. There is an unfortunate soul that was hit with too much child support 4 years ago, and there's an unfortunate soul who was hit with too much child support 2 weeks ago. Which one should be first in line? If they both have a 15% variance, they both stand in line at the same place. So I'd just ask you to consider that. If you get rid of the 15% quick in the door, or if you raise the barrier, the person that was more than 2 years ago will be first in line and probably should be first in line. Second point, as far as the parenting time, I would ask that it not be considered. I would suggest that parenting time is going to cause a lot of problems, and I would ask that it be remaining at 120 days or higher if it's going to remain. The point is, I'm going to have conversations with my client. For instance, custodial client, mother, I say, what kind of father is your husband? He's a wonderful father. How much time should he have with the children? As much time as he wants. Right now, I say, wonderful. Give him all the time he wants. Unfortunately, with the passage of this bill, the next sentence is going to be, if you give him all the time he wants, there's a financial disadvantage to you. You've got to consider that. I don't want to have that conversation with my clients. Thank you.
Thank you, Mr. Kessler. I'm sorry, I will let you know. Back to where we were before. Mr. President, I'm looking at Senate Bill 382 FA2 is the legislative council number at the top. Is this the bill as came through the Senate as a final bill, or is this the one that was introduced to the Senate? You, off the top of your head, know.
I hesitate to speak since I'm not 100% positive, but that number will typically indicate the bill as passed.
This is the bill from the Senate. Okay, so it has the amendments included that were passed by the Senate. Yes, sir. Mr. Crawford,
I've got a question. Can you tell me did you plan on passing this bill out today or trying to perfect it?
that's what we're looking at doing now, is perfecting the bill. If there are amendments or changes to be made, discussing those changes, hopefully having time to consider a passage of the bill today.
Thank you, Chair.
Next question. Anybody wish to discuss the bill? Mr. Lindsay.
Chairman, I've got two proposed amendments. One should already be in your folder. The second one I will put you now. That's for your consideration.
Why don't we take one at a time? I suggest we do that before we start spreading that without getting much paper moving around.
The first one, Mr. Chairman, tries to make a bridge between the two points of view regarding the 90 or 120 issue. What I'm concerned about, as expressed by Judge Abbott, is that under both the original 382 and underneath the amended 382 that passed the Senate, you have in both situations a cliff effect, in which, quite frankly, whenever you hit that certain point, whether it be 91 days or 121 days, somebody goes over the cliff, where you go from no impact on child support to suddenly 10%. And I think that's an enormous hit to face in one day. I'm also concerned, quite frankly, with the original version to begin having a 10% cut at 90 days. I think that's far too draconian and does not fit with most people's economic realities as they're trying to budget their home. Therefore, my proposal, Mr. Chairman, would be to have a gradual increase beginning at 91 days. And you will see in your thing. And it takes it up. And what I've done is I've used the bill as passed in the Senate in terms of the breakpoints. 10% at 121 days and up from there. And then I have allowed, however, for a gradual increase up to those particular percentage points over a period of time. Mine, for instance, starts at 91 days, and you have approximately a 0.3 increase each day as you pass through time until you get to the 121-day period, which you're at 10%, which is exactly the same percentage as in the original, as in the Senate bill has passed. You then gradually take it up to 20% at 137 days, which is once again the exact same percentages as was in the bill as passed in the Senate. You then go from there up to 30% at 152 days, which, like I said before, exactly what's in the Senate bill. And then you take it from there all the way up, eventually reaching 182 days, 50%. By doing this gradually, one small amount per day, I think that you reduce the chance having a cliff effect in that kind of severe kind of litigation that would take place as a result of trying to fight over whether or not to hold the line at 90 or 91 days. So I think we allow them to spread it out over a period of time, and yet preserve, I believe, the spirit of the amendments that were offered on the Senate floor in terms of the percentages on those receiving days.
You want to accept the questions about your proposal?
Yes.
Mr. Bruce?
Yeah, I apologize. You know where I was at.
Yes, sir. I understand.
I apologize. So this may have been addressed. But with all of these different, this schedule, so to speak, is there anything in here that requires that the non-custodial person who now has this financial benefit of getting the kid for a certain amount of time, is there anything in there that says that that person, the non-custodial parent, has to spend the time with the child, as opposed to picking the child up, taking them to grandma's house, picking them up, taking them to anywhere else, daycare, just so that they can get the financial benefit that's being described?
No, there isn't. There is some type of, because that would be an issue if we take it up, of course, whether or not the parent can handle that issue with spending the that would have to be subject to conversation from a motion
Have the court address it, you mean?
Yes.
Okay. Anything else?
But that would then require an additional expense on the custodial parent to have to go through that litigation or that court proceeding in order to get an answer to that question.
Although the point is well taken, perhaps somewhere within the bill, if we could item that further on, make sure that they are actually get this answered out. I don't object to that.
Okay. Yes.
We can. We will address that point in a moment. Let's get through. Keep that in mind. Ms. Oliver.
Procedurally, Mr. Chairman, did I miss it? Is there a motion on the floor for the bill, and this is a proposed amendment, or are we just discussing?
We're just going through discussions right now. I decided to open up because of the length of the bill and the amount of things to be discussed. Wanted to, if people had ideas, present those on the committee so that the committee members can review various ideas.
I'm thinking to myself, does this proposal increase litigation, conflict, and doesn't hurt? I'm just arguing to myself on both sides. If you have every day it's equal $5, and you're studying, you spend X amount of more your time studying this chart, is that going to increase conflict or not? The average visitation agreement that I draft right now is over 100 days. And Mr. Kessler's concerned about the generosity of the two working families, the care, the cooperative sharing is going to go away. I'm going to make a substitute motion if a motion is made.
Let's talk about discussions right now. If you got a discussion or point you want to suggest as an alternative, we can discuss that.
We're going to make an alternative to leave parenting time division because it's more costly to the parents and more injurious to the child.
That, Mr. Chairman, would be my first suggestion. And I do have one other as well.
Any further discussion with Mr. Lindsay's proposal on the time adjustment?
When we consider Lindsay's amendment ancillary to days, anybody have a feel for them? We should change the definition of the word day. Give me a better feel.
We can certainly look at it. One of the concerns that's been raised by several people reviewing this was a provision, I believe, inserted by the Senate as an amendment. Always questionable how thought through an amendment like that, which has such a drastic change. All right. Keep that in mind. Keep that in mind. Mr. Crawford.
Chairman, I understand your desire to pass this out today.
I am only saying that I'm cognizant of the time limitation we're working in. We're going to have another hearing Thursday. We've got a number of bills on that calendar. So I want to go as long as we thought this committee we can go looking at this
Chairman, I'm certainly not trying to challenge the chair on your desires, but I do think, given Mr. Reese's proposal, given Mr. Cummings' concern, I would feel much more comfortable if we could even have a call meeting to work some of this out today, to discuss it today. Even if you had a call meeting tomorrow, to try to make sure that, and I understand the time limit, but I also understand in haste we make many mistakes.
Keep that in mind.
And this is such an important factor. I just caution us to make sure that these are dangerous times.
This committee, as a body, is probably more familiar and I think more qualified looked at it because of the extensive work we did last year on it. And I'm certainly open to what you're suggesting, Paul. We'll keep that in mind. In that point, let me ask this of the members we have here today. Is there anyone who would not be capable of attending a meeting tomorrow afternoon at 2 o'clock or upon adjournment? Is that with the will of the committee? Everybody will be available. All right, that's something we'll keep that in mind then. Further discussions on possible changes of the bill that they want to discuss, Ms. Oliver.
I have 2 amendments I'd like to discuss. Another day, they get us more people here too. I want to delay the implementation of this until January. I'm very concerned about the OSA, particularly in large counties. And I also want to propose an amendment discussion that we raise from 15% to 25%. I don't have a feel about whether I want to combine that with the priority.
So priority what I do?
Priority of litigants, which is some people.
You know, if I speak to the chair on this point, I've had discussions with Representative Lindsay and others. A lot of people over the years have entered into agreements addressing how monies will be paid out, whether it be alimony, child support. I think one of the ladies addressed that in her discussion as to what is the way people weigh things in transferring assets. Even we'll transfer something in one hand, and I'll provide you something else in the other hand, and that other hand included the child support. Well, the court's not going to be aware of that. That information is not something you can glean from looking at the agreement that the parties reached in preparing for that. But it was negotiated. And I'm suggesting one of the things we may consider is setting aside, this may be your other amendment, is that right? I'm getting ready to talk about it. We're going to talk about that. There is I think a way we can address that by saying if parties have consented to an agreement, we, the legislature, should not go in and disturb a contract that was made between the parties, and that disturbance would be by saying we're going to allow you to find a way out of it by recognizing some percentage changing because that agreement was reached through negotiation. It's not like the court saying thou shalt do something and then it's directed by the court looking at a figure. Now it may be something the court looked at initially and did an award of say 20% for a child or 27% for 2 children. But still the parties at some point sat down and resolved, and that was still one of the things as an issue being negotiated. That's just a thought we have about it. Mr. Lindsay.
My suggestion is something I'll work out just begin talking on this place. The talking point is come up with a 2-tier system to look at these child support orders differently if they were a result of litigation decided upon by a trial judge, which the trial judge was, applying the old standard versus an agreement, as the chairman mentioned. The 2-tier system I had, short is basically 15% deviation if it was the result of a court order as a result of a contempt of trial, and 30% if it's the result of a negotiated agreement between the parties. I thought that could handle a lot of the concerns we've heard from the audience.
Yes, sir, Mr. Crawford.
I'm not opposed to Mr. Lindsay's amendment. However, one of the reasons seems like we're practicing law because all that. And I would like to
Folks that are rich.
propose a different than what the committee proposed, and making this act only apply to divorces that are granted after the implementation of this. Mr. Chairman, let me tell you why I say it. There are a lot of cases that may not be litigated. However, part of those, part of it is litigated, part of it is agreed to. But it comes down in the final order that you're not going to be able to tell what was litigated and what was agreed to. And I would propose that this only apply to cases where the final order was entered after the implementation of this.
Okay, you won't have any real modifications other than normal modifications. Normal law modifications.
Take place on any order that would be entered prior to the implementation of this, and because I think what you're fixing to do is, I think it's a mess up. I mean, I'll be honest with you. And I don't have a problem.
I'm sure the courts.
If you're going into your negotiations with the ground.
And I know the courts will be grateful for that. We have, yes, sir, let me just mention something. We have that as an issue because right now what you have from the time the divorce is entered, you've got a right to seek a review really immediately. After you seek your first review, then you're limited to waiting 2 years before you can refile from the final order entered in the previous one. So that's what so if we do nothing, that's what you still have in the law. And I'd say you can have somebody still come in today, and effectively it's the first time they filed a modification,
yes,
seek that modification. Mr. Hatfield.
Chairman, I understand that it's been stated here, and truthfully so, I think that some people have negotiated agreements for lower amounts of child support or specific amounts of child support based on waivers of alimony or property concerns, what have you. But I think, first of all, everybody that does that knows or should know going into it that doing that and making concessions or changes on child support is not proper to do that. And secondly, that if they've done that, then they've already shown a willingness to concede on child support in order and what is right for their child or children in order to get something for themselves personally. And in my opinion, I don't think that a contested case or an agreement, I don't think those should be handled any different. I think that we ought to stick with 15%.
I think we got everybody's opinion. That's what we're talking about. Ms. Oliver?
The reason that's not true is there's settlement is a comprehensive package. And it's not, you don't negotiate for the debt because you care about yourself versus your child. It's a comprehensive package. You don't negotiate for alimony versus child support because you care about yourself and not your child. It's a comprehensive package. That's relevant.
All right.
Mr. Lindsay's amendment, which I brought up.
Other comments or discussion for potential amendment to the bill from committee members? Let me ask you to do something. I've got a document here that was presented to us just as the committee started by Ms. Centerfit. And I know Ms. Centerfit to be a very qualified, capable attorney, and she has brought to the committee's attention some things I want to go through, which are potential things really tweaking. There may be some language that needs to be modified. And if you will bear with me, I will discuss these with you. If you go to our bill, I'll get that to you in a second. That's not her. You don't have a copy of what she is giving to me. That's why I wanted to get the right one here. Okay, here we are. First one is on page, and if you will, use your copy, SB 382 FA2 at the top. Go to page 3, line 8, this is number 4. She has suggested the waiver of reduction be the waiver or reduction of interest. would result in substantial and unreasonable hardship to the parent to whom interest is owed. Her suggestion is to change the third word of to or. I'm just going to bring these out so you can make the notations on your copy, and we can talk about it as we get ready to go through the amendment part of the process. Quickly go over to I believe the next one she has, page 12. Line 15. She suggested from excessive promotional, travel, vehicle, or personal living expenses, depreciation, or equipment, that she has striking or, comma, cost of operation of home offices, and then, comma, or excessive promotional, travel, or vehicle expense. Hey, Senator, what was your suggestion for this language? I don't know if we're adding anything or just adding a little more confusion to it.
It's just really a matter of being clear in the drafting. I think the way that this is currently drafted is we've got excessive gratifying promotional, travel, vehicle, or personal living expenses. And I think the intent, and Barry is here, we can speak to that better than I, but I think the intent is to say that if you go back up to line 12, ordinary reasonable expenses, self-employment, or business operations necessary to produce income do not include, I think we're listing all the things that are not included under the expenses of your self-employment. I think what they intended to just say is personal living expenses, depreciation on equipment, costs of operation of home offices, or have excessive only apply to that list of excessive.
Your concern is it may read as saying excessive to all those items, whereas personal living expenses, depreciation, equipment, etc. should not be categorized within the excessive portion.
And this is really a grammatical question, but when I read that, my partner and I went back and forth on what was the intent. I mean, I think we know what the intent is, but drafted this way, does it accomplish the drafters?
Well, you do have depreciation, which may be a recognized expense, but you do have sometimes the right to do what we call accelerated depreciation, which would then perhaps come in the category of being excessive.
And if you have the right to do accelerated, then that shouldn't be excluded, should it?
Well, it doesn't say it. It says depreciation the way you do it then. All depreciation would be excluded.
I guess it really is a question of what was the intent of the drafters, but I think it's arguable that they weren't intending to make excessive apply to each and every one of those.
We'll keep that in question. We'll go over to page 23. Senator Pitt suggested on page 23 a change of a word. Line 7, the court or jury shall take into account all non-excluded sources as opposed to non-exempt sources of income available to each parent. What's your thoughts here, Ms. Senator Pitt?
My partner knows more about tax law than I do. She tells me that that's the proper phrase to call it non-excluded as opposed to non-exempt sources of income.
All right. The question there is to change on line 7 of page 23, that one word from exempt to excluded. Any questions on the committee meaning of the term? I'll write that on mine. I suggest y'all write these on as we're doing it, because I'm going to go back at some point. We'll have a discussion with amendments. Change non-exempt to non-excluded. Next thing we have, let's see, is page Is that all you had, Ms. Benefit? Get the tables next. Is that covered?
I have flag all pages in this one.
I'm sorry?
Sorry, I have flag all pages only on your copy.
I don't have any of them flagged. Just I'm going through where I've seen something written in.
Oh, I'm sorry.
I don't see flags on. I think it's all I recognized anyway. Okay. Let me, any other thoughts, amendments-wise, before the committee members? I have some things I'm going to bring up. You had something you were looking at, I believe. Was that right? No? Get back to my folder. Ms. Travis, yes, ma'am.
29.545. Some of those are corrections, but I don't know if you talked about that one yet.
No, we haven't. 29.0549? No, 45. I've got so much paper for it now. Here we go.
Those are suggestions from the commission rather, and some of those are other things.
All right, these are, have you got in front of you, committee members, AM 29.0545? These are some suggestions that came through for the commission, as things they picked up since their last review of this. And let's look at them right quick on page 26. The first one they have is on page 26. Oh, I'm sorry, page 24. I missed that one. Beg your pardon. Let me go back. Page 24. I'm sorry, you got to strike that. Page 3, line 24. Page 3, line 24. They're suggesting that inserting between support and the period the phrase and Schedule E pertaining to deviations. What I would suggest we do is write those things in that we have here that we can talk about it either as an amendment, or you want to do it as a group amendment. We'll get to it.
Yes.
Prefer that? Okay. The second one on the sheet we'll look at is on page 19. Striking lines through 26. 20 through 26. And inserting parties, including the Child Support Enforcement Agency.
That's because the duplication in paragraphs 4 and 5, that was an amendment made in the Senate that language got copied over twice, and it should only be copied over once.
Okay, actually,
If you basically just go on like going in after all the pages of period, you should just strike the rest of that.
that's what you're really doing, right. So we're striking after the end of the period of agency, then the rest of that entire paragraph would be omitted. Okay. Third one we have on page 24. Lines 2 and 3. Starting in between lines 2 and 3, a paragraph C1. Now let me ask you, Ms. Travis, do we want to use this C.1 or go through and do a re-numbering of those paragraphs that is added?
When I produce a substitute, it would be my intent that we would all we have three numbers and
Good.
others throughout.
Okay.
But this correction here was because the cross-reference in 19-6-34 that takes into account life insurance.
Right.
And so that's why that changed from that standpoint.
Okay. So we have that other paragraph being inserted as a new paragraph on life insurance. Any questions regarding proposed amendment? On page 26, line 35. striking line 35 and inserting in lieu thereof the following. And the amendment is on line 35, striking it. It says, create a difference of 15% or more between the non-custodial parent basic child support obligation and a prior award.
That's the current language. This amendment was changed, was put in, lead in the Senate, and we don't have anything that really defines what a new award is. Basically, what we're talking about is the non-custodial parent's basic child support obligation. That's why that's terminology.
And we're putting in the phrase between the non-custodial parent's basic child support obligation. There we are.
Yes, sir. You would strike out line 35 other award and insert the defined term.
And the prior award, yeah.
And that changes the next amendment on page 27 on 8.
Right. Over to page 28, and the next one. That's the same change. So this is an area that talks about other possible changes. We'll get these in to begin with. All right. At this point. Yeah. That is to insert in lieu of the following of the non-custodial parent's basic child support obligation. I'm going to follow this from line 8.
So you're basically on line 8, you're starting from the word of child support. Starting from those words and inserting non-custodial parent's basic child support obligation.
All right.
That's the proper terminology.
Next is going to be on line 9 of page 28. That's one. Just not, sorry. Lines 27 and 28 on page 45. The next one. Still on that page. 27, page 20, line 8, page 27. Okay, yeah. Line 9 of page 28. Yeah. Same thing.
Basically what we're doing is we're saying that whenever order will have attached to the Schedule E, Schedule should only be the deviation.
And Schedule E, okay. Shall be, all right. Next is on page 45. I'm going to suggest the amendment, once we get these reviewed, and they go ahead and pass these amendments you got to put in to the draft for the bill to come back to us tomorrow. Page 45, lines 27 and 28, inserting a new section 4.1. The purpose of this would be to what?
That's the cost reference that wasn't picked up initially. Actually, this is probably what I was burial in the state from last year. 19-6-34, there's language that deals with life insurance. And because we're saying life insurance now is deviation, that's the language. In current law, we say it shall be counted as part of child support. And under the new child support bill, what we really are saying is it may be considered a deviation.
Under certain things.
So it brings the bill, brings the current code into the language that is appropriate, especially to this bill.
All right. Any questions about that proposed amendment?
And the next section is the cost reference change from the letter 19-6-15, subsection D became subsection E, so that's that change.
Okay. Do I hear a proposed amendment, Mr. Bruce?
I'm really consistent with the council. We actually hold that thought.
Sure, go ahead now.
What I'm trying to do is make sure that if this passes, that there's some requirement that the time that's being used to calculate this is real time, and that the person is not just dropping off the child at a daycare center, dropping them off at a babysitter, and they get the benefits, for.
You want to say that at the time the non-custodial parent actually retains physical custody for visitation purposes of the child. Sure.
We're saying that the child spends more than 12 hours in the calendar day, that used to be defined in the original bill, calendar day, with or under the control of the parent, and that parent expends a reasonable amount of resources on the child during such time very directly related to the care and supervision of the child. And then it's on line 11. Child is under the control of the parent when the child is in the parent's home or at school or related daycare or such activities the parent expressly permits. And I'm just sharing with you the process of the commission. That was their effort to include language which goes to your concern. I can't tell you whether obviously this is meeting your concern, but that was the language that the commission saw fit to include to incorporate the idea that you can't just drop them off at grandma's house because we're talking about extending resources and being under control of the parent.
But even in that, being under the control, the parent is not present. I can basically say I'm taking this child to a child care facility and leaving this child there. And the child is still under my control, technically, because I left him there. But I'm not with him. But I'm also in a position where I'm reaping a benefit by virtue of this schedule. Reaping a benefit that limits my liability to pay child support. And not as that, but the custodial parent that money. And I'm not willing to do anything other than picking the kid up and drop him off. So I don't know if this addresses that.
What we can do, Bruce, is you can speak with legislative counsel if you want to try and get something worded up that may be your interest satisfying that question. Any other proposed amendments from the committee? I've got one. Yes, ma'am, Ms. Hall, I'll get you.
I thought what we were doing procedurally is going through some technical amendments, but you really are asking.
I want to discuss it now. Things you want to propose.
I've already discussed it.
You got yours out?
Yes, sir.
Okay. One thing I want to suggest we look at also is the issue about direct appeal. I want to talk about this because we've had a change, and what you might address, Ms. Travis, is a change of the recommendation that came from the commission dealing with the issue of to be factual issues tried by jury. We had that limited before as being only that question about determining what is the income or what is the amount of money, gross income to be considered in the preparation of the worksheet. I think the commission proposed a different approach which broadened that part of it. I said because when we debated this last year, we were looking at the limitations of the right of a jury trial weighed with the question of if the court did something wrong, there was going to be this direct right of appeal out of the only issue addressing the award of child support. And there's not any other rights of appeal in our code dealing with divorce as a direct right of appeal. Everything else is discretionary. And we just get Ms. Travis to answer that point first. Go back to what the commission did. During the year when the commission looked at the question about the factual questions for determination by a jury. Do you remember?
I believe it's reflected on page 2.
I mean, to catch you off guard, there's one thing I'll tell you about. That goes, in the language you're speaking of is what? Except that all final child support orders shall be directly appealable, and as provided in paragraph 9 of subsection A of the code right now. But the question was, Judge Abbott addressed this when she spoke to us. We originally had it set up the only factual issue for determination by a jury was going to be what is the gross income. And I understand that's being changed under the Senate Bill 382 as part of the proposal from the commission. Am I wrong?
It was enlarged to include deviations.
Pardon me?
Yeah, and the jury will also now look at deviations.
Deviations, that's right. The question of deviations as well as gross income.
Right.
So we left that more, again, the whole question about determining child support. And the issue now is not to have a direct appeal. I know the appellate courts are concerned about this. I think you have still, which is the current way, is to file a application for appeal, and it's discretionary, and that will still be true. There would be a right of discretionary appeal. We're going to have a report from Ms. Nesbitt. In fact, Ms. Nesbitt, you're here. Why don't you tell us some more about that point, if you would. Deborah Nesbitt from the Administrative Office of Court. Think about those.
Thank you, Mr. Chair and Committee. I appreciate the opportunity to be here today, and Chief Justice wanted to express her thanks for being invited to come over today. However, out of respect to you and your legislative role, she sent me over to give you an update on the pilot project. But wants all of you to know that she has an open door policy, and that if any of you want to talk with her about this issue, or if you specifically want her to come and testify, she'll be more than happy to do so. In response to complaints by the Family Law Section, in 2003, the Supreme Court implemented a pilot project by which they would take discretionary appeals. The Family Law Section of the Bar complained that the Supreme Court was not granting discretionary appeals on domestic relations cases or on divorce cases. So they decided to implement a pilot project in which they would carve out a section of those domestic relation cases and essentially treat them like direct appeals to look at those cases. An agreement was reached between the court and the Family Law Section that the attorneys would therefore try not to file frivolous applications that would take up their time. What they've done since, I'm just going to give you some percentages of what they've granted on those discretionary appeals since they implemented the pilot project. In 2003, 78% of the application for discretionary appeals were granted under the pilot project. 27 were granted that were non-pilot project cases. In 2004, 88% were granted those applications, and 14% were granted under the non-pilot project applications. In 2005, 68% were granted on those applications for discretionary appeal. It's important to note that a direct appeal can result in up to a 2-year wait on an opinion. But by virtue on a direct appeal, it goes up. They request the record from the trial court, which sometimes takes a long time based on the caseload of those individual courts and those individual jurisdictions for that record to come up to the Supreme Court. Discretionary appeal applications are determined within 60 days. If an appeal is granted, it will follow the direct appeal time frame. But at least for those discretionary appeal applications without merit, the parties will have a resolution within 60 days instead of over a year that it would take for them to find out that their case did not have merit. The Supreme Court recognizes the need for granting discretionary appeals when the new child support statute goes into effect. Supreme Court Rule 34 specifies that the standard for granting is reversible errors appear to exist, the establishment of a precedent is desirable, or further development of the common law, particularly in divorce cases, is desirable. So I think under the discretionary appeal rule, given the implementation of this new child support statute, the Supreme Court would be taking those discretionary appeals in these cases to develop the case law. And they're committed to doing that. There has been a major shift in policy with the Supreme Court in looking at the discretionary appeals in these domestic relation cases. the court respectfully asks that if any changes are to be made to the appellate review in family cases, that it should be done after a careful, wide-ranging study that focuses on the impact to the appellate courts and the parties. There is such time for a study as the pilot project and the discretionary appeals process on these new child support cases will provide valuable data and information critical to any appellate process review or revision. At this time, if anybody has any particular questions, I know y'all have had a long afternoon, so if anybody has any particular questions, I'll be happy to try to address those.
Any questions from any members? All right, thank you, Ms. Nova. That's something we'll consider as part of what we're going to be changing.
Okay, thank you.
We have also the sheet in your file, which is the called recommended technical amendment to Senate Bill 382. We did all these, the different sheets. That's what I'm looking at. Okay. These are the same ones you have in your draft out amendment. Okay. Back to the, let me suggest, if I might, for the purpose of our discussions, not taking the bill as a whole, but the proposed amendments under AM 290545 to have Legislative Council prepare a redraft of the bill, including just these amendments. Would that be acceptable to the committee? Any questions about that? These are technical amendments? These are primarily technical amendments, yes. We'll have a motion made to adopt and print. All in favor of the motion, signify by saying aye. Opposed, like sign. We'll have you prepare those for us, Ms. Travis. Let's talk about anything else as far as the discussions on Senate Bill 382 at this time. I want to suggest tomorrow what we'll do with the agreement of the committee is we'll meet again in our committee room if it's available. I think it will be at 2 o'clock or upon adjournment for consideration only of Senate Bill 382. We still have other bills on Thursday's calendar. Everyone's in agreement. Thank you. We'll still adjourn at, yes, sir? 2 o'clock or upon adjournment. Yes. Therefore,